uh, in this series of our lectures on polity, Indian polity. Now we are going to move forward with another article and another fundamental right. We have already seen few of the fundamental rights, starting from the beginning, right to equality. Then we went to right to freedom, and we have discussed all the reasonable restrictions which have been imposed on the right to freedom. Then we have also seen the preamble, what it is, what are the meaning of the terminologies given inside it, how everything in the constitution finds its source in the preamble, and how it is very important and a basic structure of the constitution. Now we are going to move forward with another article, Article 20, which is also the fundamental right, which is given to people of India, the citizens of India, and it talks about three important things. We are going to discuss that. But before that, let's just see the different categorization of the fundamental rights which has been done in our constitution. We have the right to equality, which we have already studied. Then we have right to freedom. That means what has been mentioned in the preamble: liberty of thought, expression, faith, belief, worship is also reflected in freedom. Equality of status and opportunity, it is reflected in right to equality. Then right to equality, we have right to freedom. We also have right to profess our religion. Then we have right against exploitation. And in all these series of rights, we also have right to freedom of a person. That simply means it combines three articles: 20, 21 and 22. Right to freedom of a person. And how does it define the right to freedom of a person? Article 21 talks about life and personal liberty. It gives you the fundamental right of life and personal liberty. Through several interpretation of this article and through several judgment by the Supreme Court, this article has taken a very huge turn. It has become mammoth. It has become very huge. And everything practically can be merged into life and personal liberty. So this one big article and the other two articles on the either side of these, article number 20 and article number 22, this 22 talks about a person who has been arrested and a person under preventive detention. Person who has been arrested, there shall be several rights of the person who has arrested also. See, rights have been given to free people like you and like me, who have not committed any crime as of now and doesn't wish to commit in future. The rights have been provided to the free people of India. But what about the people who have been accused? And what about the people who have been prosecuted and punished, who have been convicted and then in the jail? There has to be several rights for them also. Also, there are rights for preventive detention, that a person is arrested or a person's movement or resident has been forced to be changed to maintain the law and order. Several times it happens. Preventive detention is one of the clauses given in the fundamental right to maintain the law and order of the state, to maintain the sovereignty, integrity of the nation and other things. In the similar fashion, if you are accused of something, you are accused of a criminal charge, there has to be several fundamental rights to protect you. Until and unless those fundamental rights are given to protect you, when you are accused, the state can create havoc in your life. The state can go on accusing you with so many things, incriminating yourself there's a concept of self incrimination where you can be made witness against yourself. The tortures in the police stations and the third degree treatment can go on increasing if the protection under Article 20 is not given. Also, any law can be applied on you retrospectively if the protection and the immunity under Article 20 has not been given. Let's say if you commit a crime today, which is not an offense, tomorrow Parliament can make a law and retroactively, that means whatever has been committed in the previous date can be made as an offense. So the immunity against such act of the Parliament is also being given under Article 20. That means when you are accused of something, then you shall not be compelled to give statements against yourself. You cannot be made a victim of being a witness in your own case. In a similar way, you shall not be punished for the same crime twice. So all these concepts have been covered under Article 20, and the immunity and the protection has been extended to all the people. So we have already studied right to equality, right to freedom. We will study the right to religion and right against exploitation in the coming classes. As of now, what we are going to study are these three topics, these three important articles: Article 20, Article 21 and Article 22. For the purposes of this class, we are going to focus only on Article 20. Article 21 we will come on the next class. So let's begin with Article 20. So Article 20 have three clauses. Let us discuss all the clauses one by one, and then we can go on understanding the meaning around it and several interpretations of judiciary around it. If you see Article 20, clause 1, it talks about ex post facto law. Ex post facto law. Clause 2 talks about double jeopardy. And clause 3 talks about self-incrimination. All these are legal concepts. They have been derived from the legal jurisprudence, and they all talk about several powers in the hand of state. If they are misused, they can be against the rights, the human rights and the fundamental rights of the citizens. So it is very important to put a bar on all these things, to put limit to the power of the state in order to protect the fundamental right of the citizen. One by one we will understand what is ex post facto, what is double jeopardy, and what is self-incrimination. So let's come to ex post facto law. Ex post facto law tries to change any activity and make it an offense in the previous date. To simplify it, let's consider that if you have committed an act in 1954, let's say you commit an act in 1954, any act which is not an offense, and in 1956 Parliament brings a law making that offense punishable. If you commit the same act after 1956, when the law has already been made, that particular act will be punishable according to the law. But in 1954, such act was not punishable. But what if in the law which has been brought by the Parliament writes, and it mentions in the law that this law applies retroactively. That means any such act committed before 1956 will also be punished. This is called changing the law retroactively, mean in the previous date. So if you have committed an act which is not an offense, the general clauses act is there. Under general clauses act, the word offense has been mentioned. It has been defined. The word offense has not been defined in constitution, but it is defined in other acts which are there. In one of the act is the general clauses act, is defined. The offense is an act which according to the law is punishable. Is punishable. So an action or omission, an activity or inactivity, whatever it may be, if according to law that is punishable, that will be called as an offense. Okay. So here in 1954, what you are doing, you are committing an act, not necessarily an offense, but an act. Drinking a glass of water is also an act. Going to the washroom is also an act. You cannot be punished for this. So it's an activity. We do all sort of activity every day, every time. You're sleeping, you're waking, you're brushing your teeth, then you're eating. Everything is an activity, but not necessarily an offense. When does it become an offense? When in law it has been described and several punishment has been imposed on that activity, then it becomes an offense. Murdering someone, that's also an activity, but it is an offensive activity. It is an offensive activity. It is punishable by law. If you actively commit murder, if you actively take life of another person, another human being, that has been defined in the law as a punishable act, hence it will be called as an offense. So coming to the example of ex post facto law, if you have committed an act in 1954 and that act is not an offense, but in 1956 Parliament brings a law and declares that act as an offense retroactively, that means any act committed before 1956 also will be taken as an offense, then that activity of the government makes it powerful to bring all the actions which you have committed under scrutiny. Then Parliament has the power. Parliament becomes sovereign. Parliament can do anything. If Parliament, let's say there is a majority government who has to wants to take some revenge or wants to fix some person who has done some act, some opposition leader, let's say, who has done some act in 1954, and in 1956 the Parliament thinks that he is causing trouble for us, because of him we may lose the next election. So in 1956 Parliament brings a law making any activity he did in 1954 as an offense, and then books him and then puts him on trial and then prosecutes him and punishes him, so that he doesn't become the problem in the next elections. Anything can be done. So to protect the citizen, to protect the fundamental right of the citizen from being exploited in this manner by the Parliament, Article 20 Clause 1 declares all the ex post facto laws as abhorrent, as invalid and unconstitutional. So this is what Article 20 clause number 1 says, that to protect you from any activity of the Parliament which can declare any act as an offense in the previous date, you will be protected, immunity will be extended to you. Or else Parliament can declare any law. If you remember the the case, the Nirbhaya case, one of the accused his age was below 18, and at that time the age for the adult to be tried in a criminal activity was he has to be 18 or above. So there was a demand throughout the country to change this law and bring it down to 16. Several scientific evidence has also been provided to prove that even a guy who is 16 years of age has the capability to commit a crime like that, a heinous crime. So that act was changed and the age of adult was reduced from 18 to 16. But that particular person who has committed the crime in the Nirbhaya case cannot be tried with the new law, because when he has committed the offense, the law was that an adult has to be 18 years or more. If he has to be tried under some heinous crime, he has to be 18 years or old. Below 18, he will be considered as adolescent. So this definition was changed, but it cannot be changed retroactively. It cannot be done previously. I mean, no law can go on and change the date of the offense, change the cannot put any activity from the previous date into the present one. That simply means any activity done in 1954, we are coming to the same example, and a law which has been brought in 1956 cannot declare the activity done in 1954 as an offense and punishable under the law. That will be unconstitutional, invalid and abhorrent. So I hope you have understood this. The second aspect, the second angle which has been provided in the ex post facto law is that if you have committed an offense, now I am saying you have committed an offense whose punishment was 6 months. Previously I was saying that you have committed an act which was not punishable under law, and the parliament has made that act as an offense in the previous date. But now I am saying something else. What I am trying to say is that you have committed an activity which is an offense and is punishable for 6 months of imprisonment in 1954. Now parliament brings a law, and the law says that any such offense will have a punishment of 1 year, will have a punishment of 1 year, not 6 months. And this is also applied for any offense committed before 1956. So if you have committed an activity in 1954 whose punishment was 6 months, that punishment has been increased to 1 year by a law which was brought in 1956. This is also a retroactive process. This is also when the parliament is amending and changing a law in the previous date for the criminal activity. This is also invalid, this is also unconstitutional, and this is also not allowed. So two things: first, changing law, and then changing punishment. Both the things are not allowed. Both the things are not allowed. There are several exceptions to this also. These ex post facto law clause is applied only on the criminal matters. It is not applied on the civil matters, in the administrative matters, and it is also not applied on the taxation front. That if government wants to tax some activity from the previous date, government is allowed to do so. For example, if you have been discharging the water coming out from your factory into the local river, and that was not being taxed, that is causing harm to the environment, and government was not taking any money. On the other hand, government is investing money to clean that river, but to stop such an activity, to put a bar on such an activity in discharging the effluent, bad and toxic water into the river, if government puts a tax on it from the previous date, let's say government brings a law in 2024 that if any toxic water, bad water has been discharged into the local river, it will be taxed. Okay. And this law is applicable to such activities which is done from 1954. So all the activities and the industries who have been running and discharging the water since 1954 till 2024 will also be taxed, and from 2024 forward prospectively will also be taxed. This is allowed. So if the government is making some change in the taxation law retrospectively, that is allowed. In some civil law retrospectively, that is also allowed. But in criminal law, where you are punished, there is some penalty or some punishment. If the penalty was, let's say, 500 and it has been increased to 1000 rupees by bringing a law retrospectively, that is also not allowed. So any criminal activity which either gives you the punishment of imprisonment or the punishment of penalty, in both these things, retrospective law will not work. Ex post facto laws will not work. I hope you have understood this concept. Now let's come to the second important concept, which is double jeopardy. What is this? If you see the double jeopardy thing, it simply means that a person shall not be punished for the same crime twice. A person must not be brought to peril for the same crime twice. If, let's say, person A has committed a murder and he has been tried and prosecuted. He have been tried and prosecuted, and he have been sentenced and punished, and he is in jail for 7 years. Now he comes out and then again he is booked for the same murder, that you have committed murder in that year. And so a person cannot be punished for the same crime twice. So if he has committed murder, let's say in 2011, and he serves 7 years of prison till 2018, and he comes out and is tried again, that is not allowed. Let's say if he is in jail in 2011 and after 2 years also he has been tried for the same murder, same ingredients in an offense, still that thing is not allowed. So punishment for the same offense is not allowed for the second time. That if you have already been punished, for a crime once, you will not be tried for the second time or will not be punished for the second time. Now there are several differences in the Western countries and the Indian constitution as far as the double jeopardy doctrine goes. The difference is that in Britain and in USA, if a person is tried and acquitted, he has not been convicted but acquitted. He has been tried for something and then the law cannot make, cannot prove his offense beyond a doubt and he has been acquitted. Even then he cannot be brought to peril for the second time for the same offense, even when he is acquitted, not punished or not convicted. What happens in India? If a person is acquitted, he can face the trial for the second time also for the same offense. He can face the trial for the second time also. This is like a continued prosecution. If you are acquitted, but then the state moves to the High Court and challenges the decision, then a next fresh trial can start against him for the same offense in India. To attract the immunity under Article 20 Clause 2, a person in India has to be prosecuted and punished. Prosecuted and punished. In Britain and in USA, not necessarily that a person has to be punished or prosecuted, but even if the person goes through the whole trial and at the end is acquitted, means usko chhod diya jata hai, even then what will end up happening is that the person cannot be brought to the peril for the second time. उसको दोबारा संकट में नहीं डाला जा सकता. But in India, what happens? To attract the immunity under Article 20 Clause number 2, इसका अगर आपको प्रोटेक्शन चाहिए तो पहली बार में आपको पनिशमेंट होना जरूरी है. If you have not been punished and prosecuted, then in India, Article 20 Clause number 2 does not apply. That you have been only tried and then acquitted, then a fresh proceedings against you, a fresh trial against you can be started for the same offense. That is the issue. Now, if a person commits an act, an action, let's say an offense, and this is an offense under two different legislation number 1 and legislation number 2. It is an offense under two different legislation and both of them prescribes different punishments. Then what will happen? The person can get both these punishments. If the ingredients of an offense are different, let's say if you have committed one activity and it is punishable under legislation number 1, but according to legislation number 2, the same activity have different ingredients. Ingredients means the oral or documentary evidences against you tells that whatever activity which you have committed is punishable under two different laws, and the ingredient, if we see, are different, because legislation 1 tells one thing which constitute different ingredients and legislation number 2 tells another thing which constitute different ingredients, but the activity which you have done is same, then also you can be punished. For example, a person is booked under POXO Act for abusement of children. At the same time, he also commits the crime of murdering him. Then can he be tried under two activities? One is under the Indian Penal Code, murder, and then second, the POXO Act for abusing the children. So these two legislation can be applied, and different punishments can also be given at the same time. And the person has to complete one term in jail and then start the next term in jail also. So for a crime or for an offense to be proved under double jeopardy immunity, the ingredients of the crime has to be same. That simply means the crime has to be proved that there is only one offense involved, not two different offenses involved. Okay, and if there is only one activity which is an offense, a person cannot be put onto peril if he has been prosecuted or punished for the same activity. So these are little nuances of double jeopardy. They may look a little confusing, but if you see very closely and focus on this, it is very easy to understand. Simple. If the ingredients of an offense are same, then you will get immunity under double jeopardy. If the ingredients are different for the same offense also, if the ingredients are different, what will end up happening is you can get double punishment for two different offenses. I hope this is clear. Now let us come to self-incrimination. What is self-incrimination? That you have been made a witness against yourself. What happens if some person is booked under a law? If some person is booked under a law for an offense, the police books him, starts the investigation, and then sometimes court provides the custody, and in the custody if the police starts third degree treatment, to obtain any information from the accused against himself, that particular activity of the police is not allowed. It is invalid, it is unconstitutional. So any kind of compulsion or force, if applied on an accused to obtain any information against himself which is incriminating him, is invalid and unconstitutional. So 2-3 things have to be very much necessary to draw immunity from clause 3 of Article 20. First, the person has to be accused. If a person, let's say, is not accused and he is making a statement under compulsion, then the protection under Article 20 clause 3 will not be attracted. The person has to be accused. Let's say if A is accused of an offense and B, who is a witness, is forced to issue a statement, then clause number 3 of Article 20 is not applicable. This can be looked after by a separate legislation altogether. But if, let's say, A, who has committed an offense and somebody compels him, there is a compulsion, there is a force to issue some statement against himself, then that is not allowed, and the statement has to bring some incriminating charge upon him. अभी मान लीजिए पुलिस ने फोर्स तो आपको करा और कोई स्टेटमेंट भी निकलवा दिया, बट उस स्टेटमेंट का कोई मतलब नहीं है, कोई इंक्रिमिनेटिंग चार्ज नहीं बन रहा है, then it will not attract immunity, then it will not be considered as self incrimination. Self incrimination उसी समय कहलाएगा जिस समय सबसे पहले you are an accused. Second thing, any statement which you are giving to the police under compulsion brings some incriminating activity upon you. That simply means if they force you to say that yes, I have committed the crime, I have committed the murder, so the moment you say I have committed the murder, that is an incriminating sentence, an incriminating information, and then you can be tried. Okay, so what is not an incriminating sentence or an incriminating information? Let's say a murder was committed in the market and police forces you to say that I went to the market. So what? Everybody goes to the market. That is not a self-incriminating statement, but the self-incriminating statement is I went to the market and I committed the murder. Just saying that I went to the market does not prove that you committed the murder. So for the immunity under self-incrimination to be attracted, you have to be an accused first. that you have been accused of the charges of murder. Then there was compulsion. If there is no compulsion, and you are giving statement against yourself without having any threat in your mind, there is no compulsion by the police, there is no outside extraneous compulsion by anybody, there is not any threat made to you, but voluntarily you are giving a statement against yourself, then it will not be called as self-incriminating statement. That is something which you are giving voluntarily against yourself, not because of some force, not because of some compulsion, but voluntarily. So in such an activity where there is no compulsion, but a person is giving the statement voluntarily against himself, it's a privilege which is given under Article 20 clause number 3, and if you want to waive that privilege against yourself, you can do so. You can issue a statement incriminating yourself, but that statement has to be voluntarily. It must not be compulsive, it must not be forced upon you. This is important to understand. So you have to be accused first of an activity, you have to be forced, you have to be under compulsion to issue a statement, and whatever statement is issued or whatever document which has been provided or whatever which becomes a proof against you has to be incriminating, means that statement, oral statement or documentary statement, is proving your criminal indulgence into any activity. If that is also not done, then that particular event will not be called as self-incriminating. So for something to be self-incriminating, first you have to be an accused, second you have to be forced by some external force, either police or someone else, and third, whatever evidence you are giving, whether oral or documentary evidence, has to be incriminating, means it is proving that you have committed the offense. And any of these conditions, if they are not met, that will not draw immunity under Article 20 clause number 3, means that will not be called as self-incrimination. So this is what is self-incrimination. Clause 3. Clause 2 is double jeopardy, where you cannot be punished for the same crime twice, and ex post facto law, that any act cannot be made an offense from a previous date. These three activities, these three clauses of Article 20 are fundamental rights. They are the protection given to a person who is accused. Or else think about it, if clause 3 is removed, what will happen? You will be forced in the police custody, in the pre-trial stage, and also in the court when the trial is going on. You can be forced at any time to issue statement against yourself, to self-incriminate yourself. See, this is the easiest thing. Police doesn't have to work. The prosecution who have prosecuted you, who is claiming that you have committed an offense, doesn't have to work. The onus to prove a crime lies on the prosecution. If somebody is coming and a state or some prosecution is coming and they are claiming that you are the person who have committed this crime, then it is upon them to prove the crime. You are considered not as an accused, but not guilty. You are innocent until proven guilty. That is the basic tenet of the law. You are innocent until proven guilty. So if you are innocent, some protection has to be provided to you, or else if, let's say, clause number 3 is removed, what will end up happening? Police will torture you, police will do third degree on you, and it can obtain any document or any oral statement from you which is incriminating you, and then you can be punished. So to avoid this and to maintain human privacy, to maintain the civilized society, civic sense in the society. This is very important, that a person shall not be forced to issue any statement against himself. For example, police comes for search and seizure and they find some document which is incriminating you. Now that will not be called as compulsion, because police has not compelled you to do something. In search and seizure they have found something. So important to understand self-incrimination. If this clause is removed, then the state can become arbitrary and can prove anything and anybody, any person or any corporation as a convict, as a offender who can be convicted. If clause 2 is removed, a person can be put into jail again and again for the same crime. This is against the natural justice. If you have committed an offense, you should be punished. And if it is proved that you are punished, you cannot be brought to the peril for the second time for the same offense. And the third one, ex post facto law. If this is removed, any activity which you have done in any point in time can be proved to be an offense by the state. So again, it is a protection provided. So this protection is of paramount importance, and this proves the constitutionality of the government, that the government is a limited government, it is a restricted government, it is not an arbitrary form of government but a democratic form of government, where the rights, fundamental rights and human rights are respected and given to people, and they have the remedy against them. Under Article 32 and under Article 226, they can approach the Supreme Courts and the High Courts in the country if any of those fundamental rights are breached or abridged. So I hope these things, ex post facto law, double jeopardy and self-incrimination is cleared. If you have any doubt, you can post into the comment section and I will answer them. Thank you very much.